I played there too. It's beautiful. What an experience.
So
When
pretty.
I played.
Wow, thank you for joining us. I'm from the Halls of Justice, and we are back with our wonderful Judge Rudolph Diaz, who joined us for our first show. And it was about, CASA, and this is for the court-appointed special advocates in the volunteer program, which is his heart, and I'm so proud of just to have him on the show. He's joining us to interview Lauren Petkin, our super lawyer from the Kolodny Law Group, and joining her is her husband, who happens to be the spectacular gentleman who actually interviewed Judge Diaz for me, and his name is Michael J. Kretzmer, certified family law specialist. You must be awesome to get this woman's attention.
As long as I do everything she tells me to do, our life has been very good. So I intend to keep doing that.
Oh my God. Well,
She's
are
a
smart
wonderful
man.
woman. She's a great lawyer as well.
Well, let's see. You look like you're barely hitting that 29 mark. So it says that you've been practicing family law for 27 years.
Yeah, yes, going on 28 years.
Really?
Family law. I started off in corporate and have been doing exclusively family law for the last 28 years. And that's probably why I enjoy drafting prenuptial agreements, which is what we're going to talk about because of my corporate transactional background.
Wonderful.
It's it starts off less adversarial than other areas of family law. And what is your expression that you say? The bloom is still...
There's nothing like a prenuptial agreement to take the bloom off the rose of love.
That's right.
Well, really? I don't know. Is that
I've always found it to be very difficult to talk about how devoted and loving you are towards somebody, but say, just in case, I want to have this agreement that will be in place to help us go in different directions.
Well, it might be very, very useful because if somebody
Correct.
gets out of line, I would pull it out and put it on the coffee table and
true.
serve breakfast. Okay. Well, Lauren, tell us, what is the purpose of prenuptial in California?
So in California, everything that you earn during marriage is community property. Anything you bring into the marriage is separate property. Anything you inherit during a marriage is separate property. And then California has all these different deviations from that and exceptions that creates a huge amount of litigation, as Judge Diaz knows, when people go to get divorced. So the purpose of a prenuptial agreement, and it really doesn't have to be for very wealthy people. It can be as simple as protecting your separate property house or a separate property business. But the idea is to protect separate property assets if you want to deviate from California community property law if you want to. In California now you can limit or waive spousal support if you want to. You can deal with debts and obligations during marriage. Some people come into a marriage with debts and obligations to prior spouses or credit card debt or IRS debt. And so it really is a roadmap of how you want to handle your financial life during your marriage or even during a domestic partnership, because in California now, community property accrues during domestic partnership. So that really is the general purpose. And I used to do it more for second or third marriages, and I really see it happening more with young people starting off wanting to protect what they own and what they're bringing into a marriage with.
See, that makes sense to me. I'd like to go on the record saying, for the man I love, if he wants a prenuptial agreement, I'm all for it. Because the bottom line is, once we're married, everything after that point is community anyway. So, but before, everything you have, baby, you can keep it. I don't mind. Because I'm sure he'll want me to keep my mother. So when does one need or not need a premarital agreement?
Well, I think this is the individual decision of people when they start thinking about a premarital agreement. I'll get calls sometimes from people and I'll ask them, it's their first marriage and they're starting off their marriage with very little, but their parents want them to have it. And I'm asking them questions to find out what's driving the reason behind it. Sometimes the reason is being driven by parents because they know somebody is going to inherit money in the future.
Right.
But what the client doesn't know is that in California, gifts or inheritance during marriage, even without a prenuptial agreement, is your separate property. You have to maintain it in a separate account and not commingle it later. So it's an individual decision, and once somebody understands the law, then they can decide if they want a prenuptial agreement. Sometimes people decide, we're not going to have a prenup, but we will maintain things separately titled, and we'll always keep inheritance separate. So it's really a personal decision, I think, if somebody wants to have a prenup or not.
Now, to me, that was $1 million statement, because a lot of people didn't know that. And so that was awesome. Now, how to protect assets without a premarital agreement?
So I touched upon that. I mean, you can protect assets during marriage without having a prenup, and you can do that by keeping assets in a separate bank account if you come into a marriage with separate bank accounts and separately titled assets. If you're going to buy something and you want to maintain the separate nature, you have to use separate property, because earnings during marriage in California are community. Mm-hmm. The hard part is people don't know the law. They commingle. Mm-hmm. They commingle separate with community, and then years later, gosh forbid, you get divorced, and then you've got to go back and trace, and it's a nightmare. But if you want to try and protect your assets, the easiest way is to keep them in a separate account, keep them separately titled. If you own a home that you're bringing into a marriage, you have to pay the mortgage and capital improvements and certain specified things with separate property. Otherwise, then the community property nature comes in. So depending on how complicated your estate is, you really can maintain the separate nature if you just want to maintain your separate assets and you're not worried about anything else.
Wow. In my head, there's a case going on right now that, boy, I'd love to talk to you about.
Well, at least it seems like you're certainly showing the intent of the parties. Maybe they don't perfect it, but at least when you end up in court, at least you know what they intended. They may not have followed the law, but you can't question that intent.
You mean if they try and keep things in a separate account and pay with separate? Yes, I agree with that.
You know, Lauren, what can you and can't you do in a prenuptial? For instance, a lot of times people will call us up and they'll want to know whether they can protect themselves in terms of child support. You know, is child support covered in a prenup? Or how about spousal support? Suppose somebody enters into a prenuptial agreement saying that neither party shall receive spousal support. And then we go 10 years down the line. Things change. How do things like child support and spousal support figure into a prenuptial agreement?
Well, spousal support in California now, you can limit or waive spousal support in a prenuptial agreement, which is unique, I think, to California, and that's relatively new. And it became codified in our family code in a specific section effective, I believe, January 2002, after a history of cases. The only caveat to that is that if you try and set it aside, if you get divorced and you try and set aside a spousal support waiver or limitation, then the court looks at the factors at the time of trying to enforce the prenuptial agreement. So, because you don't have a crystal ball, and you could be married for 30 years and one spouse isn't working, and another spouse is, and you have a wonderful lifestyle. And in that, when you're getting divorced 30 years later, to have a waiver or limitation of spousal support could be very unfair. So there is that out for the court. Things that you can't contract away in a prenuptial agreement really is anything having to do with child custody, visitation. I mean, you may not even have children born yet, so that sort of makes sense that you can't contract that away. You can't contract away child support. You can't have contractual provisions on things that are against public policy of California or illegal provisions. But so generally the idea is anything dealing with assets, debts, liabilities. You can do some estate planning, because it could be a contract to make a will, and then you have to follow up with estate planning provisions after you get married. But those are the areas generally that you can talk about in a prenuptial agreement.
Well, now I'd like to go on record and say I'm not giving up the spousal support. Okay, because if you cheat, I want to talk to you. I want some repercussions. Okay.
Well, that's an interesting Because some people want to put in no cheating provisions, and I've yet to see that tested in a court to see whether it's enforceable or not.
Okay.
People try and put in very odd provisions in a prenuptial agreement, and I'm not sure it's enforceable.
Yeah,
Well,
but
one of the
Are you saying it would void the contract if there's cheating?
Or if you cheat, then you don't get the X, Y, and Z that I agreed to give you in paragraph 7, where I agreed to pay you, X per year of marriage. Those kind of provisions.
Or if you cheat, then you have to pay. If it was a kiss, it's $5,000. A very sophisticated European couple came up with this. And if you did X, Y, or Z, then it was $10,000. And if you did, God forbid,
It's even more.
It's even more.
Not sure that's enforceable.
Now, you get all kinds of people who come to you for
Yes.
a prenuptial agreement.
Some referred by you.
That's right. And on occasion, you'll get people coming in who want advice that sometimes exceeds what you're just going to talk about the technical aspects of a prenuptial agreement, correct?
What do you mean?
Well, you get people sometimes coming in who, gee, should I marry this person who wants this prenup?
Yes.
How do you
Sometimes
handle that?
Sometimes it ends up being a
Counseling
4-month counseling session.
So what's your role as a lawyer when you get that person who comes in and they really seem to be asking you more than just how do they protect themselves with a prenup?
Well, that is the difficult line, because my role is their lawyer. I'm not their therapist. And I have a very difficult prenup now that Mike knows that I've been working on for a couple months. And sometimes you have 2 young people coming in. Prenup is driven by the family, and they come from different walks of life. And the prenup itself raises questions about finances that a lot of people do not talk about before they get married. You'd think they would, but they don't. And it raises questions about how we're going to live our life, and what happens if we live over our budget, and you spend more than me. And so it's a very fine line, because I really can't be giving counseling. My job is not to disrupt this impending marriage. I want the marriage to go forward if the client wants it. So what I try and do is say that maybe you should talk to a counselor about some of the global issues that you're dealing with, and try and deal with it in a delicate way, so that I still want to protect my client, but at the same time, I don't want to disrupt their marriage that they're planning on getting.
So do you ever tell a client, forget it, you shouldn't marry this person?
No, I don't.
Okay.
Even if she wants
can't
to.
do that. Even if I want to, I don't, because I don't want to be blamed. I've only had one marriage not go forward in my 26 years over a prenuptial agreement. And
Really?
yeah, it's not something that I enjoy doing, because it's really, people are adults, and my job is to advise them of California law. And if I explain the law and they want to go sign a prenuptial agreement based on what I've advised them, and they're intelligent and they sign this knowingly, willingly, and not under duress, that's really all I can do.
Now, I love this next question, and this is great, because it says, how far in advance of a wedding does a prenuptial agreement need to be finalized? Because we've had people on both ends of the spectrum where one person is calling in, and it's like, well, and when's the wedding date? And they have no idea. Well, I don't know yet, but I want this prenup agreement. And the other end of the spectrum is, well, we're getting married in 3 days, and we
Right.
just decided that we wanted this prenuptial agreement. So
Right.
how far in advance should they do this?
And we've gotten calls on those and everything in between. So my best advice to people is at least 30 days, if possible. Sometimes you don't have that luxury. Sometimes they call and it's 2 weeks. If I get a call and it's less than a week, I can't take it. It's just too soon. But my recommendation is at least 30 days. California has codified this in our family code, and it really was the fallout from the Barry Bonds case that I thought was interesting facts at the time, which I haven't memorized. But at the time, it was interesting because Barry, this was in 1987, and he at the time was playing for Pittsburgh Pirates, earning $106,000 a year. And he met his then Swedish fiancée, 1987, and they then moved. She moved to be close to him, and they had a wedding date set in February of 88. So in January, late January of 88, Barry's attorneys talked to her about a prenuptial agreement. And she did not have a lawyer. She was told that she should consult with independent counsel, but she chose not to. And the agreement had not been presented to her yet. The concept had just been presented to her, saying you're going to have a prenup. And I love this. Willie Mays had made arrangements for the wedding. The wedding was supposed to be in Vegas. So they were supposed to get married on February 7, 88. On February 5th, just before everyone's supposed to depart to Vegas for the wedding, the attorneys, Barry's lawyers, presented Swedish fiance with this agreement. She didn't have a lawyer. She met with only his lawyers 2 to 3 hours, and they supposedly went over it line by line, and she signed it, and the wedding proceeded.
Okay.
You fast forward to 1994, after 2 children, Barry's earning about $8 million a year,
Wow.
and they separate, and wife challenges the prenuptial agreement. This was an interesting case. So at the trial court level, and I cannot remember who the trial court judge was on the Barry Bonds case, at the trial court level, they held the agreement valid and enforceable.
Mm-hmm.
She appealed it to Court of Appeal, and then they reversed it, saying that she didn't have independent counsel, it wasn't voluntary, and a whole litany of other reasons. Barry appealed it to the California Supreme Court. California Supreme Court reversed the Court of Appeal and upheld the agreement. And they went through pages and pages of how this agreement was voluntary. She was advised to have a lawyer. She turned it down.
Right.
A premarital agreement is different from a regular contract. She knew what she was doing. She understood English, and they upheld it. And there was a big public outcry, I think, in the family law community at the time. How can this be? So then our family code became codified, I think, a lot of it in response to this case and another case that came down on the same day from the California Supreme Court called Pendleton that my firm worked on, that had to do with the waiver of spousal. So now in California, the law is that the first draft of an agreement must be presented to the other side and the other side's lawyer no less than 7 days from the time it's presented and the time you sign it.
Mm-hmm.
So that's the current law now in California, having to do with the time period of when prenups should be presented.
Mm-hmm.
Of course, there's always weird cases that come down that are the aberration, because there's a case that came down after our code section came into effect that did not have a lawyer involved, and it was 2 pro pers doing an agreement, and then the question was whether the 7-day rule applied. But that's generally what the law is now in California.
Now, that's where I wanted to go with this too, which would be, the next question is, who should be drafting a premarital agreement, and what happens, and this just blows me away, when people are so cheap, but they want this premarital agreement, and I only want to pay one attorney. I don't want another attorney. I want you to draft it, and just you, and we're going to sign it. Can we do that?
You can. I don't advise it. Some people do, and I think it's dangerous. I mean, the best rule of thumb, if you really want to have agreement that's upheld and enforceable, is to have 2 independent lawyers representing both parties, and I think 2 family law lawyers. I've seen several agreements over the years where husband's probate business contract lawyer drafted the agreement.
The bankruptcy guy.
Right. Or, or my PI lawyer friend drafted the agreement, and then one side was a family law attorney and the other side wasn't. And
no calls, please. I don't want to hear from the bankruptcy community. Anyway.
Yeah, and I think that if you're the one that wants the agreement upheld and enforceable down the road,
Mm-hmm.
you have to have a family law attorney, and you need to insist that your fiance have a family law attorney, because the danger is that people that don't practice family law, they don't know the nuances, and they don't know enough to counsel somebody on all the nuances of family law and what they're waiving. And that's really the issue, to have full disclosure and voluntariness on an agreement. So my advice to people is you have 2 independent family law attorneys.
There's an attorney who tries to negotiate a prenup between 2 parties, run a risk of conflict or ethical questions.
I think so. I mean, I don't know how you can represent 2 parties together and have it be an arm's length transaction when one person could be asking to waive very important California rights that they're giving up. So I don't think you can have one lawyer.
And it can be really difficult because there are lots of clients who do come to us and say, I'd like you to draft the agreement for both of us. And if you're going to do that, you've got to make very, very specific disclosures that you're not representing either party, that each party should go and seek the advice of their own independent counsel. So there are situations in which you can be the draftsperson, but you don't want to have it interpreted that you're acting as the lawyer for one side or the other, correct?
Right. I mean, clients are sort of penny wise and pound foolish sometimes when it comes to prenups. They don't want to pay for it. They're saving money for the wedding, whatever the reasons are. And I tell them it's sort of an insurance policy against your future. If you're going to have an agreement and you're going to have it worth meaning something in the future, then I think it's worth spending the few extra bucks to have it done properly.
You think? I
Right.
think so.
Otherwise,
Absolutely.
don't bother doing one.
Now I like this. So who pays for each party's lawyer fees in preparing and negotiating a prenuptial agreement?
So that's sometimes a battle at the beginning too. There's different rules of thumb. Some people say it doesn't matter, and some people, when they want the prenup, if you're the spouse to be that has the greater earning ability and they want the prenup to be protective, they will offer to pay the opposing spouses to be attorney. But
fees.
some lawyers, and I think some judges, feel that to have complete independence, each party should pay their own. I mean, I would ask Judge Diaz, do you as a judge think it matters? If you were determining the validity and enforceability of agreement, would it matter to you if husband's lawyer paid the retainer for wife?
If the husband paid
If
for
the
it.
husband paid the retainer
Well,
for wife,
I would be
wife's lawyer.
I would be less concerned, of course, if the spouse, I guess the wife, would have the right to choose her own attorney.
Right.
I think that's more important than who pays for it. I think I don't see that as a problem as much as who gets to pick her lawyer.
Right. And I agree with that. Though sometimes people will say, well, can you refer some lawyers? And I may give my client a couple names if the person on the other side doesn't know anybody, and then they have the right to either call those people or not. But I agree that, yes, each person should choose their own independent lawyer when they're doing this.
Let me ask you this. A few years ago, we made a big deal about signing ceremonies for prenups and whether they should be video recorded and who's supposed to be there, and at times we do this questioning on the record, practically like a cross-exam. Now, you understand what you're signing, et cetera. Do we still do that kind of thing, or is that an important thing to do?
I personally don't think it's that important to do. I think it depends on the case. I know a lot of lawyers still do it. I think it sometimes is very weird, and it seems very adversarial, frankly, when you're getting this agreement done and everyone's still happy and you're happy it's done, and then to have this ceremony with a court reporter or video and you're questioning, did you understand? I mean, the prenups that we do are pretty complete. We have them sign it. I go over prenups with my clients. There's never a question that my client understands it. I believe that the attorneys I work with go over carefully with their clients. So I think it depends on the client, and if you're worried about the other side, and you think the other side is maybe signing this unwillingly and under duress, and you have a question about whether they're going to, then I think in that case you would want to do it.
So you don't think that a couple wants to watch a video of their wedding ceremony and then maybe sit down later and watch while they sign the prenup?
No.
Okay.
That's pretty
But I
good.
know some attorneys insist on it.
Yes, they do.
They
I
do.
know.
It really, it's interesting how some attorneys still insist on it. But some attorneys treat prenuptial agreements as a very adversarial process.
I know of an estate planner in Newport Beach, and he videotapes his prenup agreement. So yeah, which is also the same attorney that was telling me about the couple that checked off the $5,000 for a kiss if you cheat and $10,000 if you cheat, and that was all. I found that very interesting.
Speaking of which, what's the wackiest clause that you can recall somebody making a request to include in a prenup agreement?
It depends on what you consider wacky. Custody of pets? Do you think that's wacky?
Well,
That I've actually
do people ask for
included.
that?
Yeah.
Okay.
I mean, I've had couples that have lived together and then are getting married, and custody of pets, since it's not apparently prohibited
Oh,
is
California
custody
is
of
very
children.
serious about their pets.
I have dealt with
yeah.
custody of pets in a prenuptial agreement. What
You can
happens
have the
when they
kids,
split
but I
up?
want that dog.
Yeah. Exactly. What's the wackiest provision you ever dealt with?
Well, I don't know if I've had a wacky provision, but the very first divorce I ever did was 2 lawyers down in the South Bay who were able to resolve everything, including the sale of the house, and they spent over half their legal fees fighting about who maintained priority to the Hollywood Bowl tickets.
Okay.
Oh my God.
Yeah. And they
Wow.
spent an inordinate amount of money, and this was 25 years ago or more.
Wow.
And
On just that
they're
issue.
worth even more now.
People can find all kinds of things to fight about all the time. And I did have a couple that I had a pet provision in, and the husband was to keep the dog for 6 months, and then the wife was to have the dog for 6 months, and he refused to turn the dog over.
Oh no.
So that was,
So how was that decided? Who got the tickets?
well,
Well, I would think, as you know, because I resolved a lot of divorce cases, they picked. Do you just go from the top? Which event do you want? Which one do you want? And all the way to the bottom.
Just divide
And they
them.
just divide
Yeah.
them basically, and switch off. Next year you pick first, and then we go down the list.
But see, if you have a prenuptial agreement and the person if you buy the tickets would say separate property, technically those tickets are separate property. So it goes to the person whose money went to buy them.
Wow.
how many of the prenups that you've been involved in have ended up being litigated at some point?
Thank goodness, only one that I was deposed on out of all my years, and they ended up settling the day of trial.
That's a tremendous record.
Yeah, and I've been
That's
doing
really
and I've been
very
doing
admirable.
prenups for 26 years. So
Beautiful.
I don't know if it's because the prenups are that good and they just read them and settle, or the people haven't gotten divorced yet. But I remember one in particular.
We have 51 seconds.
Oh, that went quick.
Okay, it did. It went really quick. You're going to have to come back. This is awesome. Let's see. In the state, drafted in the state which we reside. Do we have to have the prenup drafted here?
Oh, that's actually kind of an important concept because everyone's moving around today. So choice of law of where you're going to do a prenuptial agreement is important. It becomes important later on. If you're going to intend to reside in California, then most people have California prenuptial agreements and then the law of the state
Right.
of your prenup. So if the parties move later to New York and you get divorced in New York,
Wow.
for property, assets, support, they are supposed to look to law of the state where you drafted the prenuptial agreement, and that would be in California.
Super lawyer, Lauren Petkin. Join us next week on From the Halls of Justice. Thank you so much. That was
Thank you very much,
awesome.
Wanda.
That was very interesting. I thought it was.
Good
You
job.
know what? That really did save a lot of court time. Now that I think about it.